right, thanks for joining me. It is an interesting day. I've moved to a different room. This is the war room of my main office. Let me see. I've tried to add another video. You can kind of see. You can kind of see the little bit of a lag, but you can kind of see this is my war room. This is a long conference room table full of newspaper articles from various cases I've tried, cases I've handled. This is where some of the big discussions and the big negotiations go down. Again, this is the war room. I had 3 or 4 different cases today. I did them from this room. And I also have several firearms here on the desk, and there's a purpose for that. And I'll get to that. But the reason is because I wanted to do a short update video, and hopefully you can hear me all right. If you can't hear me, just mention in a comment that you can't hear me, and I'll see if I can adjust. Can everybody hear me all right? All right. So we just received the response from the lawyers who are representing Putnam County law enforcement in the Walker open carry case that's currently pending at the 4th Circuit. If you haven't seen the YouTube video, I think it's got like over 60,000 views right now of what happened to little old Michael Walker when he was attempting to go coyote through Putnam County. Then you should watch the video. If you go to my website, the Civil Rights Lawyer, or my blog site anyways, the civilrightslawyer.com, I'll show you, but I've got a link to the video, and I've linked to it many times, and I've got an update. And the reason I wanted to give an update is I wanted to show you exactly what your law enforcement leaders, what your county leaders, and this isn't just here, but this happens all over the country, what they're up to when you're not looking. What do they put in legal filings and criminal cases or civil cases that you never know about? When publicly they tell you that they're a Second Amendment sanctuary, but behind closed doors or inside the courtrooms, it's something completely different. And I'm going to show you that. I'm going to show you exactly why. All right, so let me see if I can share here. Okay. All right, so there's the website, civilrightslawyer.com. Let me see if I can make it just full screen. There we go. All right, so that's my main blog site I've been doing since 2007. There's a lot of stuff on there. There's basic stuff you need to know if you anticipate litigating your civil rights, if you want to understand what your actual Second Amendment rights actually are, or if you want to sign our petition to build a statue of Bone Smoot, which I hope you do. But the last post that I did, which just went on today, probably not a lot of people have seen it, has to do with an update in this case, the Michael Walker case. If you click on it, it gets specifically to the blog article that I did on it. So this is the video. If you haven't seen a video, you can click on it and you can watch it. Let's see. We don't need to go over the video, but if you haven't watched it, you'll see Michael Walker walking down the side of the road, basically, on his way to go coyote hunting. He didn't drive because he suffered from epilepsy. So let's see. So he had an AR-15 style rifle slung over his shoulder safely, and he had a backpack on top of that. And he was walking to his friend's house, and they were going to go coyote hunting together. Of course, several Karens called 911. We don't know who or exactly what they said, but there was a call. There was a guy who's got a gun. He's walking down the side of the road. So 2 deputies from the sheriff's department show up, been harassed by them and arrested once before for carrying a firearm for open carrying. Michael got out his video camera on his phone and he filmed the entire encounter over Facebook Live. And that's why the quality of it is not that great. But he filmed it, and you can see the entire interaction from the beginning to the end. And it seems to me that after litigating this case and posting it on YouTube and seeing the reaction to law enforcement officers, to gun people, to regular people, to grandmas, even to many Karens, it seems I haven't heard many people defend the actions of this particular officer that you see in the video, because he calls my client a C-word sucker. You would think that that would be, especially in the day of LBTGQ and all that, you wouldn't think that you'd want your employees using that word. But anyways, that's what he called them twice. It's really in my opinion, a despicable video, and I think most people agreed with that. So we filed a lawsuit in federal court. We litigated it all the way up to trial. And when we got, within a week maybe of trial, we dealt with the issues of whether the court was going to allow it to go to a jury or whether they were going to rule on the law and issue what's called summary judgment. In the end, that's what the court did. The parties filed competing motions for summary judgment. The court picked theirs. We appealed to the Fourth Circuit. Now, when we went in for the hearing, I couldn't believe my ears, because the case really had nothing to do with gun rights in particular. It just had to do with the fact that they had no reasonable suspicion to stop this guy and run a background check on him. It had nothing to do with the AR-15 or open carry of an AR-15 as opposed to any other firearm. It had nothing to do with revolvers or pistols or shotguns. But I couldn't believe my ears as we went to court on this, and all of a sudden we have discussion in the courtroom of the AR-15 being a scary black rifle, and that because he has an AR-15, he must be headed towards a school to commit mass murder of children. I really couldn't believe a lot of what I heard. But we got the order, it ruled against us, and it had a lot of that same language in it that, it says that it talks about hunting and camouflage and shotguns, and it really had nothing to do with the right and the fact that it was lawful in West Virginia to open carry a firearm, that AR-15 style rifles were lawful in West Virginia, and therefore he was lawfully doing what he was allowed to do and not breaking any law. Now, under Fourth Circuit case law, and that is the federal court that presides over Maryland, Virginia, West Virginia, South Carolina, and North Carolina, there was a case from 2013 called United States versus Black, and it was authored by one of the appellate justices, Judge Gregory. And he's looking at it, and he's an African American. He's looking at it from the point of view of growing up in the South, and the fact that police and racist local officials traditionally, especially during the Jim Crow era, used gun ownership, gun control to suppress black people. And still they do it all over the country today, but in the form of, if they see somebody with a gun and they go and question that person and grab their ID. Well, here's the thing that Judge Gregory was upset about when he authored U.S. versus Black is, well, if you're in an open carry state and you know nothing about the individual you're looking at, other than he's in possession of a firearm, but if that's legal in your state and you don't observe him committing any law because that's legal, committing any crime because that's legal, then what else are you going off of? If we allow you to do that, you might be racial profiling. And it was written from a civil rights real point of view. And so this case fell, even though Michael Walker was a small little white guy with a goatee, even though he wasn't a black guy in a high crime area, the law is the same because we're all equal under the law. And so United States versus Black had to apply just the same. Without more, in an open carry, is legal. You cannot use that as a reason to stop them, harass them, get their ID, run their background check. So that was the basis of our case, and it was pretty clear. Again, if you watch the video, you'll see that you see the entire interaction. There was no allegation that he committed any crime other than potentially not being allowed to have a firearm. So basically, he was investigated for being a felon in possession of a firearm. And that's exactly what U.S. versus Black says that you can't do. You can't say, well, that black guy or that white guy might be a felon. Maybe he looks like a felon. So I'm just going to stop and grab his ID, and I'll run his ID number to dispatch, and I'll see, just make sure he's not a felon. It won't take that long. And if he's a felon, I can arrest him. And then if I can arrest him, I can pat him down, I can find what's in his pocket, and so on and so forth. And that's what he was doing here. He was running his background check, and somebody had called, said, guy with a gun. Maybe he's a felon. So I'll check his ID. The problem is that United States versus Black, and we're in that jurisdiction that's binding legal precedence where we are, says that you can't do that. Period. You can't do that. So what happened after we filed suit, their clever lawyers came up with a different defense. They said, well, there's a school 0.92 miles down the road. Maybe he was headed towards that school. It had only been 7 days since one of the school shootings that didn't happen anywhere near West Virginia. But who knows? Maybe he was a copycat shooter. He might have been a school shooter. So that's what the lawyers brought up after the fact. And that's how we ended up on appeal. Clearly, if you watch the video, he wasn't concerned that he was a school shooter. In fact, there were no facts at all in the underlying encounter about a school, about him potentially being a mass shooter at all. In fact, the testimony when I took the officer's deposition was that he observed nothing unsafe about the gun handling. And in fact, after the encounter ended, he left and went and did something else. He didn't bother to follow Mr. Walker to see, well, just make sure he's not going to shoot up a school. He didn't ask his partner who was there to go make sure he wasn't shooting up a school. He didn't call for anyone else to go see if he was going to shoot up a school. Now, the standard in civil cases and civil lawsuits, you've heard of qualified immunity. Well, the standard is an objective one. So that means that even if this officer is a complete idiot, and in fact, he was wrong about the law because he didn't know the law, for whatever, even if that's the case, we don't judge by the idiot police officer standard. We judge civil rights violations in federal court by the objective officer standard. So therefore, even though an officer is wrong, it still might be legal because the objectively reasonable officer, who's not an idiot, would have also stopped him and grabbed his ID for some other reason that any other officer in that position would have known about. The problem with that is that there's no facts. It's all videotaped. There's no facts having anything to do with a school. And the other thing they brought up, just basically in hindsight, is, well, maybe he was under the age of 18. If he was under the age of 18, but again, the officer he clearly didn't suspect he was under the age of 18. And, if that's the argument, then it should have gone to trial anyways, because it takes a jury to decide whether or not that's BS, because he doesn't look like he was under 18. Anyways, so that was the case. We appealed it to the Fourth Circuit, and I was just not happy at all by the AR-15 language that was included. And I didn't start out in this case on a crusade to raise any sort of novel gun rights issue. It was just to enforce United States versus Black, which was very clear to me. So very very straightforward search and seizure violation. Of course, that's somewhat of an oxymoron because there's a reason I hardly take search and seizure cases unless I'm interested in the case, because they're very, very difficult to win, because there's lots of different criminal laws talking about what's an illegal search, what's not an illegal search. And there we have Michael's mother on the line. He points out that this happened around 6 o'clock in the evening, so the school was definitely closed. And that is the absolute truth. So they argued to the judge that school was in session, so that the objective officer would have been concerned that he was heading in the direction of a school that was in session. So after the hearing, Lena and Michael, I'm not sure who it was, but they dug out a screenshot of the video that showed the time. And then we got the 911 records that showed that the call came in around 6 o'clock in the evening. So therefore, school wasn't in session. However, their response to that in court was that, well, there probably was basketball practice or soccer practice or something. So in any event, that was it pointed out that their argument basis in reality. It was just something cooked up by the lawyers after the fact. So we filed our opening brief, about a month ago, and we received their response brief here just in the last couple of days. And then we get to file one more reply brief, and then it will be up to the court to decide whether or not they want to have oral arguments and whether or not they, want to just rule on the written briefs. So we don't know that yet, but I still get to respond one more time. But I just wanted to update everyone who was paying attention to this case as to what their response brief said, because you have to watch your government officials, you have to watch law enforcement when they're in court and on their behalf, exactly what they're saying, especially when you have gun rights issues that could be very important. And that's where this is going. United States versus Black is one of our best gun rights cases in the Fourth Circuit, even though it's not a Second Amendment case, because that has to do so far with pistol ownership in the home. That's how far the Supreme Court of the United States has extended their interpretation of the Second Amendment. So this has to do with the Fourth Amendment. But it's the Fourth Amendment that usually protects us when we're carrying firearms or doing anything else. So the Fourth Amendment has white knighted basically the Second Amendment for many, many years. And U.S. versus Black is one of those cases. So looking at their brief, if you go to the website, let me add it back up here. All right, so video, if you haven't watched it. But I have some excerpts from their brief. All right. These are their words, okay? This is the lawyer's written brief on behalf of law enforcement in Putnam County. Finally, Mr. Walker's argument that AR-15 style rifles may not be treated differently than less deadly firearms for reasonable suspicion purposes holds no basis in law and is contrary to the public safety and intuitive sense. Different firearms have different utilities, purposes, and common uses, and their presence therefore draws different inferences. Here's where it really gets good, I guess you could say. An AR-15 has more killing power and is more commonly used in indiscriminate public gun violence than many more commonplace sporting or self-defense weapons, and therefore raises a greater concern for public safety and context. The fact that the AR-15 is so notoriously popular among the deadliest mass shooters also raises reasonable concerns over a copycat mass shooting. Objects need not be illegal for their presence in appropriate context to contribute to reasonable suspicion. And there's no reason for the bearers of AR-15 style rifles to receive special protection. Okay, so that is from law enforcement. That is their official response in this case to the Fourth Circuit. Therefore, all right, what do you think of the phrase killing power? Now, as I mentioned, is that a scientific unit of measurement? How are shotguns okay? Or bolt-action hunting rifles okay? I wonder if they're aware of what the diameter is, or the caliber is, of an AR-15. I wonder if they know that it's almost a 22. So I have All right, I have an AR-15 here. This is set up for hunting. It's got a scope on it. It's got a accurized fluted barrel on it. It's got forged upper and lower receivers. But look how little the bullets are coming out of there. Okay, it's got a compensator on it, which just it allows reduced recoil. So these things hardly recoil at all. Just a tiny little hole, almost a 22 bullet comes out of there. So it's basically a 223. In a lot of states, you can't even hunt with a 223 because it's not powerful enough in their state's opinion to kill deer or larger game. They use it for varmints like coyotes. They refer to it having more killing power than shotguns. I mean, that's absurd. I mean, shotguns have what those are like 60 plus. So shotgun at close range. Historically, the weapons that we carried for self-defense were all more powerful than the 223 round or the 5.56 round that shoots out of a 223. So I can show you, for instance, this is an early assault rifle used for self-defense or hunting, military work. And look at the bore on this. Look how much bigger that is. Now that's a smooth bore. But even the early rifles from the 17th century, we're talking about 50 plus caliber, a lot of times 58 caliber, 60 caliber, even bigger from a lot of the German guns. So the idea, the claim has no basis in the video because the video shows everything. The whole argument of whether an AR-15 has more deadly power or killing power, there was no evidence even presented about that because it's absolutely wrong. An AR-15 shoots fast in terms of bullet speed, bullet velocity, but it's a very small bullet. The main advantage of an AR-15 is the fact that it's low recoil, easy to use, accurate. It's a rifle, and it has the ability to use higher capacity magazines. It has nothing to do with the killing power. In fact, it's pretty weak as far as so-called assault rifles go. So, I mean, they obviously have no idea that the hunting rifles they're referring to, a lot of times we're talking about 308 bolt action hunting rifle. I mean, that is way more 223 AR-15. And 308 Winchester is the same caliber that the M60 machine gun that Rambo shoots fires. 308, the M60. So they don't know what they're talking about, and it has no basis in the record. Or 270 Winchester. It's way more powerful than a 223 shooting out of an AR-15. So that's an absolute lie. It's a myth. It's something that these idiot journalists think when they see earplugs, yellow earplugs on the ground or orange earplugs, and they tweet out that they found some rubber bullets that were fired by police. I mean, these are the same idiot journalists that you can watch videos of them shooting AR-15 for the first time at the range, and they pull it up, and they're scared, and then they're gonna flinch, and they pull the trigger. It's like, and they're like, God, it's so scary. They don't realize that it barely even recoils. I mean, it's a tiny little round. I mean, they don't know what the hell they're talking about. These are people that grew up in the city. All right, so then the claim that the AR-15 is not commonly used for hunting, such as a deer rifle or shotgun, or carried for self-defense. Oh, hold on. Yeah, let me read the next quote before I get ahead of myself. All right, this is what they said. This is a suburban, residential, and commercial area. This is where the encounter took place. And again, these are their words. which is, quote, unsuitable for hunting or target shooting. And Mr. Walker was not wearing any items of blaze orange or anything else which would signal to an observer that his intention was hunting. Again, you'll see that it's a pattern. These people equate the Second Amendment with hunting, with the right to kill a deer, when in fact, it has nothing to do with that. I mean, it has something to do with that because that's one of the reasons that we wanted to ensure that people had the right to keep and bear arms, but it wasn't even on the top 10 probably. The main thing was the ability to project a military level of deadly force because the people were the militia. We were required to be armed. That was the whole idea of our country, where we didn't start off with any standing army. We didn't want one. Back to the quote. Furthermore, this interaction occurred in February when almost no commonly hunted animals, with the exception of noxious pests, are in season. I guess they inserted that as referring to coyotes because they didn't know until I pointed out that coyote hunting was in season at the time. Nor is an AR-15 a weapon commonly used for hunting, such as a deer rifle or shotgun, or carried for self-defense, such as the handgun possessed by Mr. Troop in black. Again, they're referring to U.S. versus black there. So again, the whole hunting thing, again, that has nothing to do with the underlying facts, except for the fact that he was actually going coyote hunting. But it has nothing to do with the Second Amendment. It has nothing to do with gun rights. The gun was legal at the time to carry. Open carry was legal. He wasn't breaking any law. He wasn't observed or reported as having broken any law. You can't just be afraid of AR-15s if you're a police officer or anyone else and go perform an investigatory detention of him, run his background check just because you're afraid of AR-15s. Again, how is that an objective standard? The objectively reasonable officer shouldn't be afraid of a completely legal AR-15. Our rights don't end where they're feared. So a deer rifle, what the hell does that have to do with any of this? But deer rifle or shotgun carried for self-defense. All right. So are they saying that deer rifles are commonly carried for self-defense, or that shotguns are commonly carried for self-defense? And the fact is, in West Virginia, you don't have to have a handgun or a pistol for open carry. It can be a long rifle. That's the law. You don't like it, move somewhere else, or lobby the legislature, as people do, to restrict our gun rights. The fact is the state of West Virginia and many other red states have chosen to liberalize our gun rights as our founding fathers wanted them to do, or wanted us to be. And there's been a trend of trying to stop that, and law enforcement using the courts to try to stop that, because they may say one thing when they're calling themselves Second Amendment supporters and a Second Amendment sanctuary, but you look at their court filings in cases such as these, or in criminal prosecution cases, and see what they say there. Let's see. Hillbilly, that's a good point. Next time you hear someone say we need to protect some guns for hunting, tell them that Paul Revere didn't ride his horse and yell out, "Big deer with antlers are coming." It's exactly right. It's a common misconception held by our very own governor here in West Virginia and our Senator Joe Manchin, both of whom are big, huge FUDs. If you don't know what a FUD is, I did a YouTube video several videos back on what FUDs are. And it's not somebody old rifles, because I love old rifles. I love hunting rifles. I love bolt action rifles. It's somebody who thinks the Second Amendment is about their right to hunt deer, and who at the same time wants to stop you from having a scary black rifle, for instance, because it scares them, or because you're just a peasant and they're the ruling class. And that's what you hear from our governor, who's a billionaire. When he was teaching kids about guns, he was talking about how, he has a bird dog. He has a bird dog. He grouse hunts, and boy, does he grouse hunt. Oh God, he loves to grouse hunt. Oh man, he grouse hunts all the time. But he just can't deal with the idea that just any John Doe could go pick up a gun, go buy a gun and carry, with no training, no thousands of acres, bird dogs to hunt on. That's a training. We can't allow peasants to do that. That is a FUD. That's a FUD. And the regular people out there, we don't think that way, because we're not billionaires. We understand that we have to preserve everybody's rights in order for us to exercise them ourselves. It's not the American thing to do to say, yes, we have rights, but only the upper class or the chosen ones get to use those rights. You peasants, you have to apply to us for the ability to use those. Rick, why do we have such incompetence by our public servant? This will take a whole nother video. Hang on. It's obvious to you that they're for a settlement or stalling. I can tell you that that's not true. They've had the ability to settle this case. They've had the ability to settle this case. It's not about money. They got insurance. It's not about money. It's about policy. They asked the court for guidance. They want guidance. And what is guidance to them? Well, West Virginia has anti-police laws, like allowing people to open carry firearms. And that endangers us. We may not make it home at night, and they shouldn't be allowed to do that. If we see somebody with a gun, we better damn well be able to stop them and check their ID. And if they're a felon, we arrest them. That's what it's about. That's what it's about. You look at all these law enforcement cases, and that was the problem with Scalia as well. As great of a Supreme Court justice he was, you look at all these Terry cases, U.S. versus Terry. This is where we've lost more rights in the last 60 years than anywhere else, is with these Terry searches, where courts have allowed police, because being a police officer is dangerous, which it is, and it hasn't been any more dangerous than it is right now. And I can sympathize with that. But it's not just police officers who are in danger. We're all in danger. So we should not just extend self-defense rights that we have naturally anyways to police officers. We all should have them. Kyle Rittenhouse should have them. We all should have them, not just police officers, but you have a lot of cases from the Supreme Court and in the circuit courts since the 1960s, when Terry first was handed down, allowing police officers to perform a Terry search for officer safety in all sorts of situations. And what that does is effectively allow them to do a search, even though they don't really have probable cause. And that is a whole nother video or set of a dozen videos on the scope of Terry searches. But there was just a Fourth Circuit case called United States of America versus Curry just a few months ago. I think it was July, really restricting Terry searches for bystanders such as Michael Walker. And it talked about United States versus Black. And it was a case out of Richmond. And I'll get to a post on it at some point, but it was a case out of Richmond where several Black guys were walking from a high crime area where some police officers who were like a drug unit heard some shots. And so they heard the shots, they ran or drove to the area, and they saw 3 or 4 Black guys walking away, one of whom looked like he was favoring his arm. They stopped him, performed a Terry search, found his gun, and litigation ensued. I think he was charged with being a felon in possession of a firearm. So as his criminal defense lawyer said, he wasn't observed committing any crime because they didn't know he was a felon. So they weren't allowed under the Fourth Amendment to stop and ask him if he had a gun or get his ID or to search him for a gun. And they came down on our side. Even the Fourth Circuit did here just a couple months ago, finding that there was no reasonable suspicion. And I think that might be important to this case. And that happened long after this case happened. But still, the officers in that Curry case, they heard gunshots. So they believed that there was an active shooter situation in a high crime area with a lot of people because I think there were housing projects. And so they get there and they observe people acting what they thought were suspiciously, one of whom looked like he might have been wounded. They had way more reasonable suspicion to go question those guys or stop those guys or investigate further than they had with Michael Walker. All they had was some anonymous Karen or Karens who were scared of guns. Michael Walker, if you watch the video, he said, "What law have I broken?" And he was exactly right. He hadn't broken any law. And the officer responded that, "Well, if I ask you for ID, you got to give it. That's it." And he was wrong. Michael was wrong. He was exactly right. He wasn't suspected of having committed any crime, just like the guys in Richmond. Whether or not he was a felon in possession of a firearm, the officers didn't know that. What were they going off of? They didn't like his skin color? Well, they had a little bit to go off of. He looked like he was wounded in the arm, talking to each other, acting somewhat suspiciously, and there was an active shooter situation actually going on. In Michael's case, there was no shots. There was no report of any criminal activity whatsoever. It was just a guy with a gun. And that very clearly is not reasonable suspicion of any crime. So they're trying to say that if any police officer is scared because there's a school down the road, that you've got no rights. They can stop you. They can get your ID. They can run your background check. They can lecture you. They can harass you. They can call you a you-know-what sucker. And that brings up another point. I mean, at some point, common sense comes in here, and this never had to even be a lawsuit. All they had to do is treat him like a human being. And speaking of Black Lives Matter and ACLU, you know what the ACLU is doing? They're trying to get these little Marxists, these Antifa guys, to threaten our state legislators for banning them off of social media. And they're threatening to sue them for that. What else are they doing? They're threatening to sue every school or school district in West Virginia over LGBTQ bathroom issues. That's what the ACLU is doing. The world's on fire. The country's on fire. And the ACLU is worried about bathroom issues. In 15 years of litigating, investigating, settling, negotiating civil rights cases, police misconduct cases in West Virginia, I've never had 1 ounce of help or even contact from the ACLU. I have been contacted by the FBI. I've been contacted by the Civil Rights Division of the Department of Justice. I've been contacted by Good Samaritans. Never been contacted by the ACLU. Anyways, back to what I was talking about before this video gets too long. Let's go to, oh, yes. They were talking about the fact that AR-15s aren't used for self-defense. ACLU equals FUDs. They're not even FUDs. They want the total abolishment of any firearms rights. How can you support so-called civil liberties? How can you say we want to advocate for the Fourth Amendment but not the Second Amendment? We don't like that because we're big liberals and we don't like guns. And yet you also advocate for abortion, and there's no amendment in the Bill of Rights that mentions abortion. Abortion's not mentioned anywhere. Where the hell's that come from? I can tell you where it comes from. You can read Roe versus Wade and the other cases, but that's a whole lot of, that's just making stuff up. So-called right to privacy. We're talking about something that's actually written down. Amendment number 2, like second most important. Why wouldn't you support that? And maybe they are supporting it somewhere, but I don't think so. They like more than they like actual civil liberties. Yeah, because they are another Marxist organization. Well, I'm sure they'll really love me now. So where did we hear about an AR-15 being used in self-defense here recently? I could swear that something happened just recently where an AR-15 was openly carried somewhere in an urban area, and then it was used in self-defense. In fact, if I recall correctly, it was caught on video from different angles. Oh, yeah, that's right. That was the Kyle Rittenhouse case. That was the Kyle Rittenhouse case, where a 17-year-old kid was openly carrying an AR-15. They're not saying that that was illegal. They're not saying that they had the right to grab him, stop him, seize him, arrest him because he was 17. The AR-15 was legal in Wisconsin. Open carry of AR-15 was legal in Wisconsin. Doesn't matter if you're going hunting. Doesn't matter if you're going nowhere. Doesn't matter if you're attending or trying to protect property from armed rioters. And that's in fact what happened. And he was violently attacked, and he used his AR-15 in self-defense. And we'll see what happens with the Rittenhouse cases. But that's going to be a crucial case in, I think, the history of our culture and the history of our country. And I really hope that they're doing a good job on that case and not just trying it only in social media, but I hope someone's really buckling down and preparing for the criminal defense side of that case, because you know that the government's throwing everything that they can at that poor kid. And I, he was fighting for his own life. That video shows that night, but now in his fight for the rest of his life, and his criminal case, he's fighting, I think, for all of us. The ability to protect ourselves with an AR-15, because if you know that you're going to get attacked by an Antifa guy who, I don't remember if he was a sex offender or not, but he's armed with a Glock pistol. Well, what do you want? You can grab whatever you want. You've got your handgun, you've got your shotgun, you've got your bolt action 308, and you've got your AR-15. You got 30 rounds of ammo, and you could have another magazine, but you didn't. Okay? That's why our military uses basically the same rifle, except a fully automatic capable weapon, because it's the best. A small 17-year-old can put rounds on target accurately, as demonstrated by the videos of Rittenhouse. I can't believe that they didn't actually mention, maybe they did, I didn't see it, but they didn't mention the Rittenhouse incident in their response brief. I wonder why. And I didn't mention it in mine because we'd filed our opening brief, if I recall correctly, before that was happening. Maybe I did. I don't think so. I got a lot going on. I'm traveling tomorrow on the other side of West Virginia for a trial of sorts. So I only have so much stuff in my brain that is not essential at the moment. But what are you going to use? You're going to use an AR-15 if you're smart. This has been argued. In the firearm version of bro science. There's no good argument against not using an AR-15 unless it was some legal issue. So it's actually ideal for self-defense. It was designed for self-defense. One person can defend themselves against multiple armed attackers. But you know what? It doesn't have to stop at that, because to exercise your right to open carry, there's no requirement in West Virginia or in other states that you have to have some stated purpose of what you're doing with it. Legally, he could have strapped it on his shoulder just because he freaking felt like it. Maybe he didn't want to go hunting, but hell, he's bringing his AR-15 with him. It doesn't matter. You know what? It's none of the government's business. Let's see. Yeah, I feel bad for Kyle. He's a political object now. It's not about his rights. Yeah, it's going to be really interesting to see what happens with that. Back to the task at hand. They basically just slander the AR-15 after that. I'll put it back up. And this is from their brief. The mass shooter's preference for AR-15s is because, this is funny, as former U.S. Marine infantry officer and author of The Gun, A History of Assault Rifles, Their Effects Upon Security and War, C.J. Chivers. That guy must be a piece of work. C.J. Chivers wrote in a February 28, 2018 New York Times column, when a gunman walked into Marjorie Stoneman Douglas High School on February 14th, he was carrying an AR-15 style rifle that allowed him to fire upon people in much the same way that many American soldiers and Marines would fire their M16 and M4 rifles in combat. In sum, AR-15 style rifles give the wielder the capability to kill more people in a shorter amount of time than more commonplace styles of firearm, making it an appealing choice for a would-be mass shooter whose goal is exactly that, and a greater danger to public safety than would more commonplace, less powerful, lower capacity firearms such as shotgun or handguns. Well, I mean, they don't know what they're talking about. First of all, I have numerous Glock 17s, Glock 19s, chambered in 9mm. I have 33 round magazines. This AR-15 only holds 30 rounds. But with a regular magazine, maybe it even holds 20 if I'm hunting with it. A Glock 19 with a 33 round mag, I can have 34 rounds. That's a higher capacity. So they're wrong. Shotgun. I mean, hell, 12 gauge shotgun. Watch the video I did the other day of me shooting 12 gauge shotgun with a double aught buck, comparing it to a flintlock. It kicks the hell out of you. I mean, double aught buck 12 gauge is a hell of a round. At close range, it's way more powerful than the 223. Now, it's not going to reach out like a 223 does. But when we're talking self-defense, we're not talking about reaching out anyways. We're talking about face-to-face type of stuff, very close. All right, fiery but mostly peaceful. Soldiers in Vietnam hated the M16 due to its limited stopping power. In fact, the Army is going to a 6.5 to increase lethality. I don't know what the Army is doing. I've heard lots and lots of campfire arguments over the M16 in Vietnam. I think, just to go down that rabbit hole just very briefly, I think the biggest problem with the M16 in Vietnam had to do with the fact that when they first issued them, they didn't teach people or provide the proper equipment on how to keep it clean, because that is the one downfall of that system, is that it does get dirty because it expels dirty gas back into the receiver that, if not kept clean, it can foul up and stop working when you need it the most. And whether or not it was stopping power or not, I don't know, because they were using, I believe, 308s, and like with the M14, I think that shoots 308, doesn't it? But I mean, they were using, so it was a step down in killing power and stopping power. So it's exactly the opposite of what the hell they think they're talking about. As a military, we decided to go to a smaller, less powerful, less lethal, less deadly round. But it's light, since it's less, since it's a smaller round, it's lighter, and we can carry more, and we can fit more in the magazine. So if we can only carry 200 rounds, I'm just throwing that out there, of 308, we can carry 600 rounds of 5.56 or 223. So I think it had to do with the ability to, as warfare changed, to, you want more ammunition. And again, it has nothing really to do with this here, except for, I mean, we've had it since the 60s, and it's still, the design is still basically the same that we're putting out there on the battlefield today. If our soldiers, who many of them do get to choose, especially with the special forces and smaller unit guys, the elite tip of the spear types. I mean, I know a couple of them, and they love AR-15 still. That's what they take into war. That's what they have in their home, because there's no real design that is allowed, for you to defend yourself as effectively as with an AR-15. Not because it's so deadly, but because it's easy to use, accurate, modular, customizable, readily available, light, and detachable magazines, and all that stuff. in my opinion, anyways. While I'm talking about that, I mean, let's look at the fact that what is American history. Take a look at this. I've shown this before. This is a German Jaeger. It was originally a flintlock. The Germans brought our rifles to America. It was part of the creation of the American long rifle, but it was brought to us by German immigrants, really. And this is where they came from, a German Jaeger. And look at this German Jaeger. All right, watch this. It was a flintlock. It had an expert. It was converted to percussion early on. So you fire. All right, you originally flintlock right here, but you fired your one barrel. Then watch this. Let me see. I had to pull that back. There's barrel two. See that? Double barrel. Double barrel. This is 18th century. 18th century. This is before the Declaration of Independence. This is before the Revolutionary War. This was here in America. This was technology that we had. That was our assault rifle of the time. Here's another one. This is an American-built Frontier smoothbore Fowler that was used here on the Virginia frontier. You can see it's not a rifle. This was used in the French and Indian War and the American Revolution. This has been in the museum at Fort Pitt in Pittsburgh. And it's basically a shotgun, but it can also shoot the rifle balls. You know, if you're in the woods in the 18th century frontier, you can shoot a turkey with this thing. You can shoot a British redcoat. You can shoot a Tory with it. You can use it for self-defense. You can use it for offense. What is the military? How do you know this had a military use? See that hole right there? That hole? That was for a sling swivel. That was like the military piece of equipment of the day. Has a sling swivel. So for military use, you had to have a sling. You had to have sling swivels. Generally, civilian-used arms, purely civilian-used arms, did not have sling swivels. So this was a military-use gun. You can see that a soldier had his name carved into it. And it does have some carving and decoration, but it's a really long gun. But this is just one of those salty frontier warfare flintlocks. That's part of our firearms history. And then we moved into the first real assault rifle, the Winchester, which was an improvement on the Henry. This is an 1866 Winchester, which saw military service. You can see that it has, let's see, 1876 carved into the stock, and the guy's name, P. LaFan, whoever that was. But this is chambered in 44 Henry, and I think it was like 14 rounds. Every time you could do that, it could fire. It was a game changer for self-defense and for the military. They were sold to civilians and they were sold to military. This was widely distributed. And if just like the AR-15 was marketed and sold to civilians, the Winchester was also marketed and sold to civilians. But it was also state-of-the-art military weapon. And that was part of our American history, is to be able to defend yourself if you're moving west and you're going through Texas or you're going through the Comanche territory. I mean, they could shoot you 10 times with a bow and arrow off their horse before you could load a smoothbore flintlock. But with this equalized things. And so it was primarily, the value was self-defense. And that was part of our history, is the fact that we have led the world in the development of firearm technology because it was necessary on the battlefield. It was necessary for civilians who were in danger moving west. And the AR-15, likewise, at this point, isn't it clear to us that this is necessary for us law-abiding civilians who are potentially looking at buses full of communists being brought to our communities to burn our businesses, to burn our homes. They bring guns. They have criminal records. They don't even live in the community. It's clear to all of us who are paying attention that our Second Amendment is exactly about having AR-15s, just like it was about having the Winchester, just like it was about having sling swivels on our Fowlers, or rifles on our flintlocks, or rifle barrels. So it is all self-defense. Repeal the 1934 NFA. Yes, that's again another video. The 1934 NFA, National Firearms Act, was passed in response to all the gangster stuff that was happening with fully automatic weapons like the Thompson, being used by the early gangsters from New York and Chicago and all that. And the basic result of it today is that it's just a big hassle for those of us who are law-abiding citizens and want to have fully automatic guns or suppressed guns or short-barreled rifles. Let's see. I give everyone permission to buy whatever gun you want. Well, thank you, Jesus. I guess that's settled. When Jesus has told us that we all have his permission to buy whatever gun we want, and we can make our own decisions. Well, thank you, Jesus. Rusty Shackford, great TV show. The AR M16 needs to be clean, unlike the AK laughs in range mud test. So again, that's more firearms bro science. There's a lot of arguments going on over different technologies, such as piston technology, that achieves a lot of the same thing, but keeps a lot of the nasty gas from fouling the inside of the receiver. But those are things we used to worry about as Americans: is how could we make better guns that can be cleaned less, we can defend ourselves even better. Those are the type of things we used to worry about. Pro science is also wrong. Well, pro science is by definition wrong. Usually. It's been known to have been right in a few limited instances. So let me wrap things up here. There's one more section that I shared on the website that was an excerpt of their brief. So let me go over that. As discussed in the prior sections of this brief, again, this is the brief of law enforcement out of Putnam County. AR-15 style rifles have been featured in substantially all of the deadliest mass shootings in this decade. Mass murders in Las Vegas and Orlando killed and wounded over 100 people in a single event with an AR-15. Just before I continue, did you see anything or hear anything about that in the video that caught the entire encounter that's being litigated here? Was there any discussion over mass shootings? Was there any suspicion at that time of being a mass shooter? No. This is all stuff that lawyers have come up with after the fact. Revolvers and bolt-action deer rifles. I'll stop again one more time. Is that not something that should never be written in any gun rights case, any Second Amendment case, any Fourth Amendment case, pending in any court in this country? No, it's not. Revolvers and bolt-action deer rifles do not share that infamy. It's therefore reasonable to infer that a person attempting to copycat a mass shooting would likely use the weapon of choice of mass shooters. If officers are concerned about a potential mass shooter, certainly they would justifiably be more concerned by a person carrying an AR-15 than one of the many firearms more commonly used for hunting or self-defense. All right, so they tried to claim that an objective officer would have been concerned that Michael Walker could have been an attempted copycat shooter because 7 days earlier, in a way off state, this guy, the Sandy Hook shooting happened. So what did that? If he's being a copycat, what was he copying? the kid who shot up that school, or was it Sandy? Whatever, the one they're talking about. I try not to even think about this stuff. But the school that got shot up that they're referring to was 7 days earlier. How did he get there? He didn't walk there on the side of the road. He didn't open carry to get there. Actually, had nothing to do with what Michael Walker did. You know how he got there? He took an Uber. So why wouldn't you be suspicious over anyone taking an Uber in the direction of a school? And the guy that took the Uber, he wasn't open carrying. No one knew he had a firearm. He had a black bag, and inside it, he had an AR-15 style rifle. So no one observed him with it in order to stop him. So if Michael Walker was trying to be a copycat, he hadn't copied a single damn thing that mass murderer did. Not a single thing. That's why it was never brought up in the video. That's why it was never brought up over the radio and the dispatch 911 records. It didn't have a damn thing to do with a mass shooter. That's just been the slander of both Michael Walker, of gun owners in general, and of the AR-15 by a law enforcement agency, law enforcement leadership, and county leadership that claimed around the same time to be a so-called Second Amendment sanctuary. In fact, Putnam County, West Virginia, was the first county in West Virginia to declare themselves to be a Second Amendment sanctuary. What a joke. Read on my website, on thecivilrightslawyer.com, read what they wrote. Read their own words of how much of a Second Amendment sanctuary they are. In fact, their words sound very, very, very anti-Second Amendment to me. Sounds just the opposite. Look how bad Virginia is with Governor Northam. You had thousands of law-abiding patriots who took AR-15s openly carried to the Virginia Capitol. And really, I don't know of them being harassed, of being subjected to background checks, being called, you know what, suckers, twice, being called sovereign citizens. I don't recall any videos of that happening in Virginia. Here we are in West Virginia, in the Second Amendment sanctuary. And this is what is coming out of them. Yeah, the Parkland shooting. Rick, thank you, Rick. Thank you, Rick. The Parkland shooting was the one that they were trying to say he was a copycat. And we don't know that this cop even knew that the Parkland shooting had happened. He didn't mention it at any time until he had lawyers, and then we got to the deposition. His testimony is that he didn't observe anything unsafe, didn't suspect him of having committed any crime. He had the barrel pointed in a safe direction on his back via a sling. He actually had a backpack on top of that. If you watch the end of the video, you can see exactly how he was carrying his gun. He never grabbed it. They never observed anything unsafe. And in fact, Michael was very polite to them. And, they never suspected him of being underage at all. The only thing he suspected him of is being a felon. That's it. Richard, they're pretty much just covering their ass. In their small minds, if you have the same weaponry as a law enforcement officer, you're a suspect. In their eyes, they're superior to civilians. There are so many cops who've seen this video who were disgusted with it, and I think who would act differently. I don't know what it is about this particular county, but this isn't the only YouTube video I've had to post of law enforcement conduct in this county. And this isn't the only lawsuit I've had to file regarding government and law enforcement conduct in this county. I think I'll be in that county. Well, luckily I don't have to be there. I'm going to be in federal court in Huntington usually, based on what that county has done. But that county I know is full of patriots, because I can't tell you how many people from that county have contacted me. Barry Goldwater, nice to see you again. Thank you for your past service, sir. Was the local DA potentially paid by Soros? Well, here in West Virginia, we don't have DAs. We have prosecuting attorneys. I don't know this prosecuting attorney far as I know, he had no, or she had no involvement in this particular case because there was no crime. There was no crime charge. This was just a 911 call about a scary gun on a guy's back, and he's walking down the side of the road, and then, a misguided encounter between a law enforcement officer and Michael Walker. And, I'm sure everybody has a bad day. It could have been that this guy was just having a bad day. I have heard from people who were friends with this particular guy and said, he is a pro gun guy, and he's normally not like this. But, I questioned him under oath, and he didn't apologize. He didn't defend his act. He just said, I can do it. I did it. He said the video shows what it shows. There are people who are jerks in every line of work. The fact is what's more telling to me is the fact that I haven't heard of there being any discipline from that. That blows my mind. No discipline at all. In fact, your employer goes to bat for you in court, takes you all the way to the Fourth Circuit. They didn't apologize to him. They didn't give him a reprimand, as far as I know. That is even worse, because that is a failure of leadership. Yeah, and I know that Soros has supposedly been funding all these prosecuting attorneys. Whether it's happened yet in West Virginia, I don't know. For the most part, a lot of the prosecutors I know in a lot of these counties are good patriotic people. But again, I don't know what's in the water, in the water tank at the sheriff's department at this particular place, but there's all sorts of drama that has come out of it. So just in wrapping things up, remember this: you have to watch your elected leaders, especially your law enforcement leaders, because you can't necessarily always blame the individual cops, because they know what they've been taught. They know what policies are forced on them or not forced on them. A lot of times these are leadership issues. And this particular officer, this was not a young guy. He was there as a supervisor for the younger cop who was watching this unfold. He was the supervisor. He was I believe, the field training officer at the time. So remember, there's no such thing as a Second Amendment sanctuary county. LOL. There's no such thing. That means nothing. It means nothing. That's just like putting Black Lives Matter on your helmet. It means nothing. You've done nothing. You haven't helped one black man get out of prison. I have. You haven't helped one. Haven't helped one. Nothing but virtue signaling. You've done nothing. So, again, I want to thank Michael Walker for taking this on. And there was an amount of money he could have taken, and we could have walked away from this. And he doesn't have much, but he chose to fight this. And I told him I would fight it all the way to Supreme Court if we needed to. And we'll see what happens. The next thing is that we file a reply brief. I haven't prepared it yet, but if I can manage some time, I guess I'll probably be working all weekend, because I've never been busier in my life having a tyrant governor. And between the tyrant governor in Putnam County, West Virginia, and between this family court judge, which hopefully I'll have a video coming very soon on that case, I've been really, really busy. And if I haven't returned your calls or your Facebook messages, I will try to get to it. That's why I have a 24/7 answering service. That's why I have somebody, full-time answering the phone and a backup answering the phone at the office. Sometimes we get loaded with calls. Sometimes I can return calls and talk to people. Sometimes I can't. Sometimes I have to wait. So again, thank you. We've had a lot of support in this, and I want to thank you for that. And again, I want to thank Michael, and hopefully I'll have an update soon saying that they're going to allow us to have oral argument, because I want oral argument. By the way, there was oral argument in Young versus Hawaii in the Ninth Circuit today, a friend of mine. You may know him as Nolo, if you know what I'm saying, but a lot of us know him as Steven Stambula. He has a YouTube channel. He's the best advocate for the Second Amendment that we've had in recent years as far as lawyers goes. Does way more important stuff than I do. He argued, or his partner did today with his assistants, argued en banc before the Ninth Circuit, and I haven't even gotten to watch the end of it. I watched the beginning of it in a very important Second Amendment case out of the Ninth Circuit. Again, that's Young versus Hawaii. I can't wait to see what happens in that case. But there are people out there doing great work, and hopefully this inspires some of the younger generation to. I think it's become evident and more important that a lot of these battles are fought in the courts. They will continue to be fought in the courts, and the legal bars, the lawyers, it's heavily weighted on the side of the left. There are very, very few lawyers on I don't even want to call it the right side, on the side of the patriots who are seeking to save and preserve what the founding fathers gave us. So the large majority of them are the ACLU types, and there's a lot of reasons for that. But I've heard from a lot of younger kids or parents that their kids are wanting to go to law school to be lawyers, to do stuff like this, and I think that should be celebrated and encouraged. And I'm always happy to help in any way that I can. Best way to contact me is just my email. Sometimes I see Facebook messages. Sometimes I always get phone calls. If you call our office, 304-772-4999, I might have a 10-page list of people who called, but there will be a record of it. Email, a lot of times I can see it, and sometimes I can respond right then. Sometimes I make it up to respond later. But thanks for watching. What happens to lawyers under communism? Well, I think the same thing that happens to everybody under communism. What they destroy ideas. They destroy critical thinking. I think lawyers, they either get thrown out of a helicopter or they're put up against the wall. And we need to prevent that at all costs. And what's the best way to prevent that? An armed people with the hardware of the time. It's hard to throw them out of helicopters. So thanks for watching. And until next time, remember, freedom is scary. And I'll see you next time.